Hey everybody, this is Damon Moore, and I want to talk to you today about the 4 keys to representing yourself in court. You know, there are a lot of people who they want to hire an attorney, but for whatever reason, perhaps it's that they can't afford the attorney, or perhaps they decide that they just want to represent themselves and they'd rather not have an attorney. Uh, for those reasons or for others, sometimes people decide that they want to represent themselves, and so I want to kind of speak to you for a few minutes about what I think it takes if you're going to represent yourself in court. Before I do that, let me say first that, again, I'm Damon. I'm an attorney, I'm a mediator. I've been representing clients in cases since 2005. I've represented, a few hundred people in various types of cases, including domestic relations cases. And so in the process of doing that kind of work, I've discovered that there are some things that are pretty consistent, some things that I think you need to know if you're going to be able to represent yourself. So first, actually, let me say this before I even go any further. I don't think it is a good idea for you to represent yourself. I think that you are better served having someone that's a little more removed from the situation representing you. I think that's a safer way to play it, but as we were saying earlier, for many different reasons, you may determine that that's not a route you can go. So if you have to represent yourself, then I think one of the important things that you have to be able to understand is the rules of civil procedure. So let me take a second and kind of read one of the definitions. The rules of civil procedure are the standards that the courts follow when they're adjudicating civil lawsuits. The rules discover or determine how a case is supposed to be commenced, what kind of service of process you're going to have, for example, what types of pleadings or statements are going to be acceptable in a case, what types of depositions or discovery is going to be part of the case, how the trial's going to work, how appeals work, any number of things that are related to how you go about doing the trial. So that's what we would call civil procedure. And there's some good news and some bad news about civil procedure. I think the good news is that the information is available online and it's relatively easy to access. The bad news is that the information can take a lot of time to read, and sometimes that can be a challenge if you're a person that is kind of stressed for time. So, but if you're going to represent yourself, then you've got to have a full grasp of the rules of civil procedure. I'd say the second thing that you've got to fully be able to understand and grasp is the rules of evidence. So the rules of evidence are the rules by which a court determines what evidence is going to be admissible at trial. In federal courts, those rules of evidence are usually governed by the federal rules of evidence. But I'm just trying to slide out as I talk to you and see if I can get into an area that's got a little less lighting. So forgive me if I'm kind of moving around a little bit. But the federal rules of evidence govern what rules of evidence will apply in a federal court, but in a state court, the rules of evidence are usually determined by your state legislature. And you've got to understand those rules of evidence because Once you understand the rules of evidence, then you can use those rules to get your evidence in, so that you can tell your story with evidence that the court will listen to. Or once you understand the rules of evidence, you can use the rules of evidence to keep your opponent's evidence out. And sometimes it's just as important to keep their evidence out as it is to get your evidence in. So, so I think that's an important thing to keep in mind. And I've got good news and bad news, of course, as it relates to the rules of evidence. The good news is that the rules are pretty easy to find online. The bad news is that it's often better to learn the rules of evidence through trial and error rather than through reading the definitions in a book. And so sometimes it's hard to get those experiences where you are seeing how the rules of evidence play out in a real court. I'd say the third thing that you've got to be able to understand is the code. When I say the code, what I'm talking about is that specific part of the law that applies to your particular case. So, for example, if we're dealing with the family code, or if it's a domestic relations case, a divorce, a child custody matter, something like that deals with families, then there's a good chance that in your state, a family code is going to apply to the situation. If you're talking about a business matter, then it's likely that there is a business code or a commerce code that applies to your particular case. And so, as with the first two things that I talked about, there's good news and bad news as it relates to the code. The good news is, again, the code is pretty easy to find. You can track that down online without too much difficulty. The bad news is that sometimes the court uses rulings from previous cases to kind of distinguish or to illuminate what something that is in the code actually means. And sometimes you can run into trouble when you know the code, but you don't necessarily know how the judges in particular cases interpreted the code, and that can lead you to some problems. So if possible, you want to try to learn not only the code, but the way some of those cases interpreted the code. I would say the fourth thing or fourth key to being able to represent yourself in court is to understand the system. You know, the system can be very intimidating. Court clerks have been ordered not to help you, and so they don't give very good advice. Judges often are not supposed to help you, and you don't really know what you're doing. Those things can kind of leave you feeling anxious and uncertain about the actions that you're taking. But if you recognize that those feelings are normal, then it'll put you in a much better position. You'll have a much easier time understanding and dealing with those feelings once you realize that those feelings are normal. There's some things that I think you can do in order to help limit those feelings. I think one thing that you can do is attend hearings in cases like yours. So if you go to court and you're watching the way the judges deal with cases like yours, then that will help you. You can see what people are doing right and what people are doing wrong, particularly if the judge that you're watching is going to be the judge that is ruling in your particular case. There's nothing better than being able to see how that judge behaves and what that judge wants. So that's one thing that you want to do. You want to attend hearings in cases like yours. By the way, sometimes when you go into court, you feel a little uncertain. If you go into court and and a bailiff or someone is asking you, if they can help you, or if the person can help you, then you just want to say, I'm just here to kind of sit in on a case. I've got a hearing in front of this judge, and so I just want to see how the process works. And usually they won't give you any trouble when it comes to that kind of thing, when it comes to allowing you to sit in and hear a case. Sometimes they'll give you a little trouble, and then you have to use your judgment. They're supposed to allow you to sit in on the cases, and so you shouldn't have any difficulty when it comes to that. So again, attend hearings in cases like yours. You could also watch hearings on the internet. There are a lot of things that are posted online, a lot of previous hearings. Sometimes when it comes to depositions, you'll see previous depositions that have been posted, and that information is available for you to see how other people have dealt with situations like yours. You can see it. You can see it from the comfort of your own home if you want to look online. Another way that you could approach the issue is to call a lawyer and pay for a few consultations. Sometimes if you call a lawyer and you say, hey, I'd like to talk to you for an hour or two about my case, ask you some questions, get your opinion. There are a lot of lawyers that will do that as part of, or have that conversation with you as part of an initial consultation. And you can get a lot of very good information that way. Plus, you can use that conversation to feel out a lawyer and determine whether that person may be a good person for you in the future if you decide that you don't want to continue to represent yourself. Another approach that you could take is that you could go to the law library. Most counties have a law library somewhere in the courthouse. Sometimes there's a law library at a law school. If you go to those places, you tell people you're representing yourself and you'd like to get some information that can help you with representing yourself. They often know where to direct you, or the librarian often knows where it is that you should be directed. So again, those are 4 ways that you can help kind of ease the discomfort that comes or the anxiety that's associated with dealing with the system. Those 4 ways are attend hearings, watch hearings on the internet, call a lawyer and get a consultation or consultations, and go to the law library. So in conclusion, representing yourself is not easy. It should be avoided if you can avoid it. But if you can't avoid it, then you have to equip yourself to do the best job that you can do. And that is something that can be done with the right kind of focus and research and study in advance. If this information is helpful to you, then be sure to subscribe. Be sure to hit the like button. If you have questions, then leave a question in the comments. I tend to respond to questions as often as I can. We can get a good dialogue going, and maybe I can be of some assistance to you. Take care.